Bahdi is one of the people who gives us hope. Prior to 9/11, her work focused on women's rights. After 9/11, Professor Bahdi was called on to speak about things like racial profiling, and as she put it, she felt enormous responsibility to stay in that space. In the academic setting, Reem has worked to embed an ethos of access to justice in the curriculum and the fabric of Windsor law. She is described by students as a professor who is genuinely interested in her students, passionate about teaching, and uses her position as an academic to make the world a better place. She's used that same passion and commitment in so many ways. Just a few. She is an expert in court and tribunal proceedings who helps contextualize experiences of discrimination so that decision makers have the insights they need to do their work. She is leading research efforts to document and understand the experiences of Arab Ontarians in the justice system, including a foundation-funded needs assessment with the Arab Canadian Lawyers Association. And internationally, as you've heard, she has led efforts to promote human dignity and support the Palestinian judicial system by conceiving of and executing a judicial education project called Karama, or Dignity. Nous sommes ravis d'ajouter le nom Reem Bahdi à la liste des récipiendaires du prix Guthrie et de lui remettre cette médaille marquant le 20e anniversaire de la première remise de le prix Guthrie. We are thrilled to add Reem to the list of Guthrie winners and to present her with the medal on this special 20th anniversary. Reem, your work to put people at the heart of justice and your commitment to advancing access to justice is an inspiration to us all. On behalf of the Foundation, it is my sincere honor to provide you and honor you with the Guthrie Medal.
Thank you. This is very humbling for me to see everybody here who I have loved and who have supported me over the years. There are people here I haven't seen in almost 20 years, and I'm sure I haven't changed in those 20 years. I'm just so humbled that so many people made an effort to be here today. Chair Rothstein, President Wildeman, thank you for your kind words and for recognizing that we are on Indigenous territories. Honored guests, I am humbled to be this year's recipient of the Guthrie Award. Donald Guthrie represented the highest of access to justice ideals, and it is an honor to follow in the footsteps of past recipients whose efforts have made my work both easier and more rewarding. I am so deeply grateful to members of the bench, policymakers, and other facilitators of justice for leading the way. To the lawyers and community groups who harness their intellect and passion in the pursuit of fairness. To the educators who aim for better ways to teach access to justice and better arguments to advance it. To the Law Foundation, its trustees and staff, for keeping access to justice on our professional radar, for the programs that they put into place to realize access to justice, and for organizing this event today. And to all of those who are outside of the profession, who lay claim to the values that nurture a national justice-seeking ethos. I am grateful to my family, only 10% of whom are here today. In particular, my mother, my brother, my sister, my nieces, my nephews, my husband, who could not be here today for unexpected family reasons, and my son, Alex, who is my reason for getting up in the morning. Without all of you, I would have dreamed less, done little, and served few. Today, I'd like to share with you, partly through the telling of personal stories, how my understanding of access to justice has evolved over the years. I'd then like to offer some reflections on where I think we might go with access to justice. When I was a second-year law student, I received an unexpected phone call from a stranger, and I would call her Yasmin for the purposes of my story. Yasmin was a member of the Somali community in Toronto. She had experienced a personal tragedy and needed legal advice. As she explained to me, she had been medically sterilized without her consent. One can imagine the hurt and loss created by this interaction with the medical system. Her loss, however, was compounded by her larger life narrative. A few years earlier, she had lost her infant son in a tragic accident that had made the front page of the Toronto newspapers for several days running. And these stories were not always kind. Some had blamed her for the accident. When Yasmin called me, she wanted to know what she could do to find healing and vindication for the latest loss she had suffered. She asked me to help her find a lawyer. She had some questions. First, and most simply, how would the law judge her claim against a doctor? But she also had more difficult questions. Would her lawyer understand how her previous loss of a child related to her current loss? And how well would her lawyer manage the social risks that presented themselves if she found herself the subject of yet another unrelenting public scrutiny campaign? As a law student, I thought my job was to address the first question: how would the law judge her legal claim? But Yasmin's story taught me that law and legal practice, and by extension, access to justice, are far more complex. They demand an understanding of human hurt, fears, aspirations, and longing. While people need legal representatives who are highly skilled, knowledgeable, and affordable, they also often need legal representatives who will understand them in context, with full recognition of their social complexities. And perhaps most importantly, Yasmin's story reinforced for me that access to justice at its most basic structures the way we as a society distribute power. When power is abused, a failure to grant access to justice is simultaneously an entrenchment of that power, and ultimately a failure to affirm the equal dignity and worth of all members of our human society. We found a lawyer for Yasmin who helped her work through her predicament, but she ultimately decided not to pursue legal action. She feared the risks, including the risk of becoming the subject of another media campaign. She decided to find other ways to heal. Now, we've made great strides in advancing access to justice as a profession since I picked up that phone in second-year law school. And the Law Foundation, of course, has taken a leadership role in these advancements. But as a profession, we have not yet finished the work that needs to be done to make our system wholly accessible. We need to continue to understand access to justice from the perspective of users and potential users of the system. And while cost, complexity, and delay are important access to justice barriers, they are sometimes not the only barriers, and sometimes they may not even be the main barriers. I continue to try to name access to justice barriers because I believe in the power of law to solve disputes, to make individuals whole, and to forge positive social relations. And for these reasons, along with my colleagues and along with the rest of you, I try to think creatively about the conditions that are needed to cultivate access to justice. So in the time allocated to me, I'd like to just say a few words about my current reflections on access to justice. Most recently, I've begun thinking about empathy in law, legal education, and legal practice. Now, I don't know how many people have done this, but if you were to search for the term empathy in legal databases, you would find it referenced approximately 7,300 cases. And many of these cases involve sentencing and criminal law, where the question is about whether one party has shown sufficient empathy for the suffering that they have imposed on another. And this is surely an important question, but my interest in empathy comes from a different space. I am interested in whether users of the system can ask for empathy from those who administer the system and those who decide cases. And there are several sites in which empathy might arise in the practice and application of law, and several ways in which it might intersect with access to justice, but I'll highlight just two. First, empathy and access to justice intersect in institutional design and legal processes. A recent paper published in the Windsor Yearbook of Access to Justice explores the need to recognize the cost of what is sometimes called litigation stress. This paper points out that psychologists use terms like litigation response syndrome and law-caused harm to describe the damage done to some people by the litigation process itself, even when the process is working exactly as expected. And we need to do more thinking about these matters. But perhaps an even more difficult set of questions about empathy arises when we ask whether empathy should be part of legal reasoning and adjudication. Our Chief Justice, the Honorable Beverly McLaughlin, has pointed to the importance of empathy, though she does not use the word. In a relatively recent interview, Chief Justice McLaughlin explained that, quote, "What we have to try to do as judges is by an act of imagination, put yourself in the shoes of the different parties and think about it and look at it from their perspective, but really look at it and really think about it, not just give it lip service." And she calls this conscious objectivity. I'm confident that we need to think more about how to advance empathy and the law in the pursuit of conscious objectivity. I'm lucky enough to be working with a group of musicians and dramatic artists whose work also involves empathy. And over the next year, we will be joining forces with law professors across the country to examine whether, and if so, how, we might be teaching empathy in law schools using music and the performing arts. Our goal in working on empathy through music and the arts is in part to help students find a path between the kind of empathy that causes distress to the empathizer and the kind of empathy that's simply an excuse to impose our agenda on others. The former will lead to nowhere but professional burnout, while the latter leads us to colonialism. Now, people sometimes ask me, where did my interest in empathy and the law develop? And I really don't know the answer to that question. It's a recent interest, but I can't pinpoint its creation. I believe that we all write out of biographies, and we use our personal spaces, sometimes unconsciously, to explore large questions that concern all of us. So if I cast a glance back at my own journey, it may very well be that empathy has always been a part of the fabric of my life. The story that brought me to this moment is the product of tumultuous world events combined with the kindness of strangers. My family came to Canada in 1967 from the Middle East as the result of a sponsorship of a Canadian citizen from Moose Jaw, Saskatchewan. She had met us only once, but determined to help us leave war and conflict behind. And there was nothing that compelled her to do what she did except for the human capacity for empathy. And Canadian immigration law enabled her empathy for our benefit. It is perhaps here in the gratitude for the opportunities that immigration gave me and my family that the seeds of wanting to explore empathy's place in life and law began. At the same time, I have come to understand in recent years that the benefits I have reaped living in Canada have been built on the dispossession of Indigenous peoples. And I've also come to understand that sometimes legal professionals played a role in that dispossession. But most recently, I have come to learn about the profession's call for reconciliation between Indigenous and non-Indigenous peoples. And for my part, it would be unjust indeed if the empathy that brought me to this country caused me to deny the experiences of Indigenous peoples in Canada and to do nothing. But my own challenge moving forward is to learn more about Canadian history and to understand more about what true reconciliation requires, so that I'm not imposing my own demands and limitations on the reconciliation process, but instead trying to understand it better from Indigenous perspectives. And I'm grateful for the support that I receive from my Windsor Law colleagues in this undertaking. I will use the honor bestowed on me today to further this and other social justice goals. Thank you for your support and for the honor that you have given me today. I hope to be worthy of it. Thank you so much.